Satisfy, my lord.
Yes.
Okay.
Next.
Serial number 5, WPS 3097 of 12, Mr. Ravi Satendra, Mr. Sri Shankar Kumar.
Your Lordship, I'm praying for not today in this case, Your Lordship. In next week, it may be taken up.
2012 matter.
माइलट आई एम अपेयरिंग ऑन बिहाफ ऑफ जैक माइलट आई रीड इनफ्लक्चुअस हो गया हुजूर 2012 का जो पीजीटी लिए एग्जाम हुआ था उस पर है हुजूर और 2012 के बाद 3-4 एग्जाम हो चुका ऑलरेडी माइलट मेन प्रेयर इज दैट माइलट पोस्ट ग्रेजुएट टीचर पीजीटी पिटिशनर इतना मार्क्स हुआ जैक एग्जाम लिया था हुजूर 2012 में वो उसके बाद 2 या 3 बार और एग्जाम हो चुका हुजूर टीचर ट्रेनिंग.
Yes.
Your Lordship, I'll seek instruction from my client, Your Lordship. In next week, it may be taken up. I'll clarify, Your Lordship, whatever it is.
Counsel for the state submits that the writ application has been rendered infructuous. Full stop. Next paragraph. Counsel for the respondent. You are Jack.
Jharkhand Academic Council.
Jharkhand Academic Council submits that the writ application will become infructuous as the petitioner has challenged the recommendation. So the petitioner is praying to recommend his name for appointment on the post of postgraduate trained within bracket PGT teacher against the advertisement dated 74 of 2011 for which examination was held on 15 to 2012. So he submits that thereafter several examinations were held and subsequent vacancies were also filled up. First up. Next para. At this stage, learned counsel for the petitioner wants to seek instructions and inform this court accordingly. Full stop. Place this case under the hearing for orders next week.
Obliged, Your Lordship.
It is mentioned that no further time will be granted.
Obliged, Your Lordship.
WPS 3787 of 12, Mr. Virendra Burman.
May it please, my lords. My lords, this is the case where prayer of the petitioner is that he was not selected on the post of teacher pursuant to advertisement of 2011 against biology subject, and he challenged the process on the basis that physically handicapped quota 3% reservation was not allowed. Now, my lord, they filed counter affidavit.
What will happen now?
Yes, sir, I'm coming to that, my lord. They filed counter affidavit in the year 2018. They say that subsequent selection process of 2017 has already begun, and it seems that it has completed now also. So, my lord, I have no instructions from my client, my lord, but it looks that it has become infructuous, but that may not come in my mouth. That is
in this. I have heard the counsel for the petitioner, and I have heard the counsel for Jharkhand Academic Council. Full stop. Next para. In this writ application, the petitioner has prayed to select the petitioner and cancel the selected list of candidates for the exam held for recruitment of teachers by Jharkhand Academic Council on 15/12/2012 for the subject biology. Full stop. The petitioner also praised that the provisions of Disability Act 1995 should be adhered to and 3% reservation should be granted. Next para. From the counter affidavit of the state, I find that the selection process which was held pursuant to the aforesaid exam has already culminated in making necessary appointments. Full stop. Further, the appointment process of subsequent year has also been taken up, and
2017. Yes.
2017 has been taken up, and as per the counsel for Jack, the 17 process bhi khatam ho gaya na. 17 process is the process of appointment in the year 2017 is already over. Full stop. Considering the aforesaid situation as on date, this writ application, no relief can be granted to the petitioner in this writ application. This writ application is dismissed as infructuous. You said your slip. Your name will be there. I heard the counsel, J. Jan, Mr. Radhakrishna Gupta.
Grateful, my lord.
Serial number 7, WPS 4438 of 30, Mr. Rajendra, Mr. Rohit.
Milord, just a minute, Milord, I have been engaged in this case to argue, Milord. The case relates to, my lord, the class 3 employees of the civil courts, my lords, they have filed this case that they want a, my lords, pay scale in the pay scale, my lord, upgradation of pay scale in the scale of 5,000 to 8,000 or, my lords, 5,500 to 9,000. My lords, now they are in fact, my lords, seeking this pay scale only on the ground that, my lords, the clerks are having the qualification of graduate all over the state of Jharkhand, including, my lords, all establishments. They are getting the pay scale, my lords, of 55, somewhere 55,000 to 8,000 or somewhere 5,500 to 9,000. So, my lords, now what the state is telling, state is equating the pay scale along with the pay scale of the clerk of Mufassil office. Now, Mufassil office, my lord, at the relevant time, the qualification for appointment is either matriculate or intermediate. So, the equivalence cannot be established, my lords, the civil courts employees, class 3 employees, with the Mufassil offices. My lord, the law point is that, my lords, whoever declared as, my lord, head of the department office, like, my lord, विभागा अध्यक्ष उसमें लिखा हुआ है, तो विभागा अध्यक्ष का जो ऑफिस होगा, that will be treated at par with the secretarial cadre employees. So if that is being treated, because, my lord, now under the service code also, under the rules also, it is written that the office, that the district judge, my lord, is the vibhaga adhyaksh, head of that institution. So any establishment under the head of that institution, my lord, they will be equated with the secretarial cadre. So, my lord, हुजूर इसमें क्या है कि हम my request to this, my lords, is that if it can be taken in the next week, my lord, so that I can also, because in the morning I got this brief, if possible. Otherwise, not, I am ready to some extent to argue.
हुजूर मेरे पास भी फाइल नहीं है हुजूर स्टेट की तरफ से हुजूर.
Mr. Krishna, I am asking you whether have you represented and prayed for this relief before the government, or you have directly approached this court?
My lords, we represented it, recommended by the registry of the High Court. My lords, even the my lords, so many department has recommended. Only why they have not done. My lord, they say that the finance department has rejected it. My lord, the finance department affidavit shows that they have not rejected it. My lord, the only thing I will show to, my lords, all the documents.
Where is the recommendation of the High Court?
Yes, that High Court, my lord, say the registry has recommended the 3-man committee constituted. I'm just.
Where is that?
That is, if my lords may kindly, page 26. Page 26, my lord, annexure 1 within annexure 1B.
Does Bihar Civil Court staff rules throw any light in this?
My lords?
The Bihar Civil Court staff rules?
Yes, Bihar Civil Court staff rules, my lord, because their rule says, my lords, that they shall be appointed on a, my lords, state level basis, having the qualification of graduation. And, my lords, I have stated that what is my work cannot be compared with the work of Mufassil in paragraph, and this was taken care of by the Department of Personal and Administrative Reforms.
Counter has been filed.
My lords, pleading is complete, my lords. Everyone has filed a counter.
Where is the counter? Counter hai?
Counter have you counter respondent number 4 has filed a counter, respondent number 2 has filed.
Counsel for the state of the petitioner takes for some time to arrange their respective case records. First up, prayer allowed. Let's discuss next week.
Yes, sir. Next week.
Let's discuss next week.
Obliged, sirs.
Serial number 8, WPS 197714, Mr. Ashok Kumar Sinha, Mr. Amit Sinha, Mr. Jaishankar Tiwari for the petitioner.
Yes, Your Lordship, I am appearing on behalf of the petitioner, Your Lordship.
Yes.
Petitioner is prayed for quashing of annexure 11 at page 57, passed by the JAC. As this is the second round of litigation regarding the appointment of advertisement of 2011 issued for +2 graduate trained teachers, Your Lordship. If Your Lordship permits me to read the impugn order at page 57.
Read the earlier round of litigation, page 55.
Yes, Your Lordship. Page 51, Annexure 2. In this writ petition, the petitioner has prayed for a direction on the respondents to declare petitioner's entitlement for appointment on the post of postgraduate teacher of +2 level in math subject and issue appropriate order for appointment. It has been stated that the respondent Jharkhand Academic Council had published advertisement number 23/7/2011 for appointment of postgraduate teacher of +2 class in various government schools in Ranchi. The petitioner applied for the post of math teacher and he duly filled up the form in the format prescribed for that purpose. The petitioner has got all the eligibility and qualification for the post and he has obtained master degrees in mathematics with distinction and he has completed his B.Ed from Ranchi University with first division. After scrutinizing his form, the admit card for the test was issued by the JAC. The petitioner appeared in the test and obtained 238 marks, much above the cutoff marks of 172. In spite of his good record and obtaining more than the cutoff marks, he has not been selected for the post. The petitioner filed representation before the chairman secretary JAC long back on 28/3/2012, but till date no order has been passed. The respondents have appeared and filed their counter affidavit. It has been stated inter alia that the petitioner possesses the requisite qualification of MSc in Maths and he has also passed B.Ed examination. He has also obtained more marks than cutoff marks for selection, but on verification of his application, it was found that the copy of B.Ed certificate was not available. The data center did not publish the result of the petitioner for want of B.Ed certificate on record. Learned counsel for the petitioner in reply has submitted that the reason assigned for not publishing the result is not supported by the records of the respondent. The forms which were not duly filled up or which were rejected for want of the document or other deficiency were scrutinized and a list was response to the petitioner's application under the provision of Right to Information Act. After hearing learned counsel for the parties and considering the documents and material on record, I find and he has passed B.Ed examination in first. Held held the candidates who obtained 172 marks have been selected and the petitioner who has got 238 marks has not been selected. And on a most trifling ground, and that too is not supported by the on record of the JAC. Considering the above, this petition is disposed of, directing chairman, respondent number 2 to pass appropriate order regarding petitioner's selection within 3 weeks for the date of receipt of production of a copy of this order. And in pursuant to this impugn order has been passed.
Who is for JAC, JC? Counsel.
Mr. Rajesh Gupta was appearing in the person.
Yes.
If your lordship permits me to take to the annexure 1, because
Yes.
the main ground is that my B.Ed certificate was not with my form.
Yes.
Yes, your lordship. Page 38, annexure 1.
Yes.
From the right, Roman 6, point number 6. From the right, your lordship. If permits me.
Yes.
अपूर्ण गलत कोड भरने और गलत सूचना देने एवं निर्धारित तिथि के बाद प्राप्त आवेदन को अमान्य कर दिया जाएगा और शुल्क की राशि जब्त कर ली जाएगी. Means if any application is incomplete, there will be no further procedure to be adopted. And next point 7, Your Lordship.
Next point read. आवेदन पत्र के साथ निम्नांकित प्रमाण पत्र की
Yes.
सच्ची
सत्यापित कॉपी
प्रतिलिपि से
अनिवार्य होगी, शैक्षणिक प्रमाण पत्र.
मैट्रिक
And
प्रमाण
second is
पत्र की
B.Ed.
डिग्री से प्रशिक्षणिक प्रमाण पत्र B.Ed.
Yes. So considering point number 6, Roman 6, if any form is incomplete, there was no further consideration of any candidate. So taking their
Where is your B.Ed? Where is your B.Ed certificate?
annexure 3, Your Lordship, page 41.
This is from a recognized institution,
Ranchi University.
Ranchi University.
Yes, Your Lordship. And date of publication is 1st November 2010.
And this advertisement is of the year
2011. Yes, Your Lordship.
Yes. Who is for Jack?
Your Lordship, I am appearing for Jack, Your Lordship.
Yes. What is your stand?
Your Lordship, at the filling of the application form, the B.Ed certificate was not enclosed.
Then why did you allow him to sit in the examination?
Your Lordship,
Why allow him to sit in the examination? Because your advertisement clearly says if the form is incomplete, it will be rejected. And your advertisement says what has to be annexed with the form. If a document is not annexed with the form, it is incomplete. So his form had to be rejected. You don't reject it. You allow him. He gets a higher marks, and you don't select him.
Your Lordship, I'll seek further instruction. Your Lordship, just one day.
What further instruction? Seek instruction. How can you compensate this petitioner?
Yes, Your Lordship. Just one day accommodation. Let it be on the next week, Your Lordship, or any day, Your Lordship.
Instruction and seek instruction from the topmost person of your organization that how can you compensate this petitioner?
Yes, I seek instruction. Let it be not
there. Your people sitting there have really destroyed all these institutions. And it is an admitted case that the person who has got lesser marks than this petitioner has been appointed.
I'll seek instruction, Lordship. Just not to take this case, Lordship. I'll seek.
You see, the advertisement is with you, Annexure 1 at page 38.
Yes, sir.
Yes.
Yes, Lordship.
You see column number 7. You see column number Roman 7.
Yes, Lordship.
There are the first two.
Avedan.
First two entry are in bold.
Yes, Lordship. शैक्षणिक प्रमाण पत्र, मैट्रिक का प्रमाण पत्र तथा डिग्री अंक पत्र, प्रशैक्षणिक प्रमाण पत्र B.Ed.
Yes, that is in bold. These two are written in bold.
Yes,
why it was published in bold?
Because these are the required documents. Documents.
These are the documents which must be there.
Yes, Lordship. Yes, Lordship.
Take instruction. How can you compensate this petitioner?
Yes, I'll see.
Next week on the request of Richa Sanchita appearing on behalf of Jack.
Obliged.
Yes.
Much obliged.
Under the heading Orders with Defect, serial number 9, CMP number 368 of 17, Mr. Akshay Kumar Mahato.
Yes.
Limitation petition required. Further action parameter.
Defects to be removed within 4 weeks.
Serial number 10, CMP number 390 of 17, Mr. Santosh Kumar Tiwari.
Yes, my lord. I appear on behalf of the client, my lord.
2 weeks. 2 weeks. Peremptory
3 weeks, my lord.
2017.
3 weeks,
Yeah.
my lord.
Tiwari?
3 weeks, my lord.
2 weeks. 2017 matter.
My lord. My lord, actually, in this case, my lord, the one paper was required.
2017 matter.
In
What was
second
required?
appeal.
I don't know. 2017. Today we are in 2022.
My lord.
And next date, I'm not passing any peremptory order. When the court will sit physically, there will be peremptory orders and no further time more than a week will be granted. And if the case gets dismissed, this type of cases, it will not be restored also. Take it from me.
My lord. Oblige, my lord.
Serial number 11, CMP number 82 of 19, Mr. Sanjay Prasad. File defect.
I pray for
2 weeks.
Serial number 12, CMP number 141 of 19, Mr. Suraj Kumar.
2 weeks. 2 weeks to the
My
defect.
lord, I had filed one supplementary. My lord, I had filed one supplementary affidavit for removing the defect, my lord.
The
There
defects
are
have been
only
removed.
two defects. My lord, I filed the affidavit stating filing the copy of the index as well as cause of action part was
Cause of
not written
you
in
have
the
to write
notification, my lord.
2 weeks.
Yes, my lord.
Affidavit, write the cause of action.
Serial number
I have
13.
stated, my lord, in my affidavit, I have stated.
Your affidavit is, let's discuss another thing for admission next week. Which is wrongly listed?
Serial number 13 is wrongly listed.
Wait.
Serial number 14, CMP number 239 of 19, Mr. Sunil Kumar, 40
My lord, in this case, I am a state respondent. My lord.
3 weeks to remove the defects.
Serial number 15, CMP number 288 of 19, Mr. Ashutosh Anand.
My lord, defect number 2 may kindly be ignored and 1 week to remove the defect number 1, my lord. I is already on the court, my lord.
What is defect number 2?
My lord, the true copy of annexure is required to be filed, my lord, which I have already annexed. This is the order by which the
Defect number 2 ignored. 1 week's time further allowed to remove the other defects.
my lords, oblige, my lords.
Serial number 16, CMP number 434 of 19, Mr. Anjali Kumar Verma. Provision law.
2 weeks.
Oblige, your lord.
Serial number 17, CMP number 485 of 19, Mr. Mohammad Asadul Haq. One defect.
2 weeks.
My lord, in this case, I am a respondent state. My lord.
I am appealing, my lord, this case.
2 weeks, Mr. Haq, we remove the defect.
Yes, my lord. I oblige.
Serial number 18, CMP number 518 of 19, Mr. Pradeep Kumar Verma.
2 weeks time may be granted, my lord.
2 weeks.
Oblige.
Serial number 19, CMP number 770 of 19, Mr. Mithun Kumar.
My lord, in this case, altogether 20 cases has been filed. My lord, 20 cases has been filed, 19 has been restored, my lord. This may kindly be restored. Minor defects are there, may be ignored, my lord.
What are the defects?
Defects is the date is missing below the prayer portion, and the second defect is the name of the judge and the date of order has not been mentioned, my lord.
No, you have to mention. 2 weeks to remove the defect.
Oblige.
Under the heading for order, serial number 20, WPS 3427 of 2005, Mr. Rajesh Kumar for the petitioner.
Yes.
Last order we received, madam. Notice was to be served by office to the petitioner, madam. It is unserved.
Wait. Not found.
Your lordship is muted.
Yes, I know there's some noise is coming from your side. I don't know. Some irritating noise is coming from that side. Yes. Yes, what is this? Who is appearing?
My lord, I will appear for JUVNL, my lord.
Who is appearing? What is this? Yes, Mr. Minal. What is this case about?
My lord, may I submit, my lord? I do not have the file, my lord. I may be allowed 1 week time to reconstruct the file. I was also trying to ascertain who is the counsel for the petitioner, my lord.
Counsel for the petitioner can't help you.
In that case, my lord, may I apply for certified copy, my lord? A longer time may be granted, my lord.
Wait a minute. Claim for DA has been rejected. Peruse the last order passed in this writ application on 9/5/2019. Full stop. I have next part. I have perused the office note also, which suggests that the notice couldn't be served upon the petitioner as the notice was unserved, is not found. It was unserved with a note within inverted comma, not found. Oh God, it's UP. Let notice be served through the Superintendent of Police District Sultanpur, Uttar Pradesh, upon the petitioner. Uh, the office is directed to proceed accordingly.
I appear for JUVN.
Give you a slip.
Obliged.
Serial number 21, CMP number 275 of 13, Mr. Manoj Kumar Shah, Mr. Vivek Kumar.
But I appear on behalf of the
Yes, what is this?
IA number. IA for the limitation petition for conduction of delay about 1058 days, my lord. Letter rates for award of compensation. Notice was issued to the respondent, my lord, due to inadvertence.
When was it dismissed?
Dismissed, my lord, on 12/7/2010. Same was dismissed for default, my lord, on 26/7/2010 due to non-compliance of the peremptory order. Notices has already been filed, my lord, but after expiry of peremptory time.
When was the notice filed?
I made state. Well, I made statement in para 8, my lord. That the
Is
now the
when? When? Now means when?
date has not been mentioned, bro.
Then, as a vague petition has been filed. 2000 March 2013 you have filed. You refused to accept the memo also when it was informed. You refused to accept the memo also. Sorry, Mr. Counsel, I'll not allow this.
The process has already been filed.
No, देखिए आइए.
Letter award से
This idea has been filed to condone the delay of how many days? 1058 days, which occurred in filing this petition. Full stop. Next para. This petition has been filed to restore ACSB case number 13/2008, which stood dismissed for non-compliance of order dated 12/7/2010. Full stop. The ACSB 13/2018 was listed
12/7/2010.
on 12/7/2010, wherein 2 weeks time was granted by the court to file requisites so that notice can be served under register cover with AD and also under ordinary process upon the respondent. Full stop. The order was peremptory in nature as it reflects in the order that the appeal will stand dismissed, rejected without further reference to the bench if the notice was not filed within time. Full stop. After lapse of the peremptory time, the notice was not filed. The requisites were not filed. Thus, by virtue of the order of the court, by order dated so and so of the court, the ACSB 13/2008 stood dismissed. On
26/7.
26/7/2010. Full stop. The noting dated 3/8/2010. A noting was made by the Registrar General on 3/8/2010 about dismissal of this appeal. Full stop. The communication about the said dismissal was also made to the lawyer concerned, but the learned advocate refused to accept the said memo, which is also apparent from the noting. Full stop. Now, next paragraph. Now on 19/7/2013, that is after 1058 days, that is more than how many days? How many years? After more than 3 years?
3 years, man. 3 years.
After more than 3 years, an application was filed to restore the ACSB number so and so. Full stop. There was limitation, comma, in filing this CMP. If there was limitation in filing this CMP, comma, for which the office had pointed out, which fact was pointed out by the office. Thus, this application under Section 5 of the Limitation Act has been filed. Full stop. Next part. The Limitation Act. Section 5 of the Limitation Act of 1963 provides for extension of the period in certain cases. First up, it provides that an appeal may be admitted even after the period of limitation, after extending the period of limitation, if the appellant or the applicant satisfy the court that he had sufficient cause for not preferring the appeal or making the application within such period. Full stop. The word sufficient cause within inverted comma is to be given a liberal meaning, liberal construction, but it not be so liberal that even a vague explanation but it should not be so liberal that even a vague application should be accepted. In this application, the grounds have been mentioned. In paragraph from paragraph 4, full stop. From paragraph 4 onwards, I find that the petitioner herein tried to explain the delay from 26 to 2013 onwards. Full stop. Be it mentioned that the case stood dismissed in the year 2010 itself, and the application should have been filed in the year 2010 itself. Full stop. There is no application, there is no explanation of the delay for the period 2010 to February 2013. It was dismissed when?
26/7/2010.
From September 2010 to January 26 to 2013, which is
July 2010.
Yes.
It was dismissed on 26/7/2010.
For thereafter, there are 1 month, more than 1 month to file this appeal. He has to explain thereafter. That means, full stop. Thus, the period of more than 2 years not only remains unexplained, but remains untouched. Full stop. So this, full stop. So this application filed under Section 5 of the Limitation Act cannot be accepted by this, is not accepted by this court. And in absence of any reasons, comma, this application is dismissed. Consequently, the CMP is also dismissed.
But my appearance may be.
You give your slip, Mr. Dev. The IA is also dismissed. The another IA is
For
currently
the last
dismissed.
15 years, Lord, I am not getting the fruit of the award. My land was acquired. The
But in this CMP, I can't help it. You have to. There is other proceedings which you have to take benefit of. Yes.
Serial number 22, WPS 2955 of 13.
Lordship, an IA has been filed for substitution, IA 3279 of 2021, Lordship. Petitioner number 4 has died, Lordship. Substitution application is by his widow, wife, Lordship. Paragraph 4, it has been stated that petitioner...
What was the prayer in the writ application?
Lordship, in the writ application, Lordship, they are wanting refixation of pay, Lordship.
Okay.
Lordship, they were half... Petitioner number 4 is dead, Lordship. Muhammad Harun.
Yes. Who is appearing for the respondents?
Your Lordship, in this case, I am appealing for Jack, Your Lordship. The petitioner is demanding refixation.
You have no objection. You have no objection if this IA is allowed?
Yeah, objection, Your Lordship.
It has been submitted by the counsel for the petitioner, IA number so and so for substitution. It has been submitted by the counsel for the petitioner that the petitioner number 4 is dead. First, we submit that since the case relates to payment of pay scale, the cause of action survives and devolves upon the wife. Namely, what is the name?
Lordship, Hafizan Bibi, Lordship.
Hafizan Bibi. First off.
In para 5, I have stated I have annexed her Aadhaar card.
He prays that the name of respondent number 4 be deleted and in his place Hafizan Bibi be substituted. Full stop. The respondent has got no objection. Full stop. Considering the said submission, this IA is allowed. Respondent number, let name of respondent number 4 be struck off and in its place the name of the wife so and so be incorporated. Let this case under the ring for admission.
Your Lordship, in this case, the state has not filed counter affidavit. State will be direct because the state has.
Let it come under the ring for admission. We will see to it.
Obliged.
Serial number 23, WPS 3173 of 15. Mr. Gautam Kumar, Mr. Sandeep Kumar Mandawal.
May I say, Lordship?
Yes, Mr. Gautam Kumar.
Okay, after 7 years, this case has been listed. I have not gone through the file properly. I am extremely sorry to say, Lordship. Earlier, one of the honorable bench heard the matter and dismissed the order, this writ application. Thereafter, that order was revoked. So my file says that. And what is the present position? Because Lordship, it was for appointment of Molvi Hafiz. So what is the present position? Whether because Lordship, so many things have been happened as I was earlier instructed by my client, but I am extremely sorry that recently there is no instruction from my client. But something has been done that I have been informed.
Let me see what is your prayer. Yes, Jack.
Yes, Your Lordship.
What is your instruction of the advertisement dated 7/5/2015?
Your Lordship, my file is also misplaced, Your Lordship. But as far as advertisement 2015,
what is this? What is the position? Latest
yes,
position?
Yes, Your Lordship.
The parties are directed to seek instruction about the latest position of the advertisements, which has been challenged in this writ application. 2 weeks.
Obliged.
Serial number 24, WPS 3570 of 15. Mr. Devakant Rai, Mr. Om Prakash Prasad for the petitioner.
This one I am appearing in this case, my lord, for the petitioner, my lord. My lord, in the present case, my lord, the
Yes.
challenge the order with if the matter relates to the interstate seniority between the petitioner and the respondent number 4, my lord. So far as the issue involved in this case, we also will take into consideration that the petitioner was initially appointed in the year 1990, my lord, as a medical officer. Subsequently, my lord, she was promoted to the post of tutor, my lord, on 6/10/2005 and subsequently posted in the RIMS, my lord. Again, my lord, in 2008, the petitioner was promoted to the post of assistant professor, and in 2012, he was promoted to the post of associate professor, my lord. My lord, my submission before your lordship, my lord, so far as the dispute between the petitioner and respondent number 4 is concerned, my lord, the respondent number 4 made an application before the respondent authority, my lord, with the RIMS itself, my lord, and they have decided, my lord, that so far as the respondent number 4 is concerned, he is senior to the petitioner itself. My lord, that order is under challenge before your lordship, my lord. Now, your lordship, kindly see the counter. My lord, paragraph 8, my lord, of the counter affidavit filed by respondent number 3, my lord, the direct.
Where is it?
My lord, that is
respondent number 3, director. Yes, paragraph.
Paragraph, kindly see, my lord, C6, my lord.
6, yes.
Stated that the petitioner at present is working as associate professor in the Department of Anatomy and she is the state government employee. Then, my lord, paragraph, my lord, 13 and 14.
Respondent number 4 is also a state government employee or employee of RIMS?
My lord, both were appointed simultaneously, my lord. My seniority.
As on date, tell me, after all these things, absorption and everything has
both are working.
The RIMS rules and everything, tell me whether the petitioner, respondent number 4, is an employee of RIMS or a state government employee?
Both are working in the state government, in the RIMS itself, my lord.
Both may work in RIMS, but tell me whether he's an employee of RIMS or an employee of state government.
Lord, you kindly see for a moment, my lord, paragraph 13 and 14, my lord, of the counter affidavit itself.
No, you tell me one thing. Whether both of you are employee of the state government or both of you are employee of RIMS, or one is an employee of a central government, one is a state government, and one is an employee of RIMS.
No, my lord, both, my lord, that will appear from the rejoinder to the counter affidavit filed by the petitioner itself, my lord. The lien which has.
Mr. Anil Kumar, just tell me, counter affidavit and submission is something else. What is your case?
My case, my lord, both are the state government employees. The state government.
Both are state government employee.
My submission is this, my lord.
Okay.
My lord,
yes, Mr. Ashok Singh, who appears for the RIM, let me clarify this first.
Mr. My lord asked a very pertinent
my
question.
friend has not been instructed properly, my lord. This is not the position.
My
Post
lord,
was advertised. I am correspondent number 4. Post was advertised associate professor. Everybody applied. I applied. Petition applied. Therefore, a appointment was made. As assistant in 1997, there was a separate teaching line.
So advertisement was made by
RIMS employee.
Both are RIMS employee.
Yes. 3 साल में तो ऑटोमेटिक हुआ अंडर दिया है. ऑप्शन अगर नहीं दिया तो समझा जाएगा कि आप इसके एम्प्लॉय हो गए. कहां से बोलते हैं जाए अपना स्टेट गवर्नमेंट वी शुड गो बैक टू द लियन.
Okay, Mr. Anil, you start.
Yes,
my lord. Okay, let him submit, my lord.
Yes, let him submit.
My lord, kindly see, my lord, Annexure 9, my lord, similar situation come up before this honorable court, my lord, in the matter relating to the Department of Gynecology, my lord.
Yes.
Page 23, my lord, of the writ petition.
Yes.
Here, your lordship, my lord, the principal secretary was directed to determine with respect to the seniority between the petitioner and the private respondent, my lord.
Yes.
The matter was disposed of. My lord, here in the present case also, my lord, the respondent number 3, the director RIMS, my lord, He has made a representation. He has recommended, my lord, to the state government to determine the seniority as mentioned in paragraph 13 and 14 to the counter affidavit.
Just one thing, let me understand.
Because of the stand which has been taken by the director, my lord, I am
Just a minute. Petitioner vis-a-vis respondent number 4.
Lordship. My lord, kindly paragraph 13.
What is your date of appointment?
My lord, almost the same date itself, my lord.
No, almost, my lord. Give me the date of appointment.
Exactly the same date, my lord.
Same date. What is the date? What is the date?
My lord, that appointment date is, my lord, so far as the associate professor is concerned, 29/10/2012.
29/10/2012. 10/2012. And the respondent number 4 also same date.
Yes, my lord.
29/10/2012.
My lord, so far as respondent number 4 case is concerned, your lordship will see, my lord, that an advertisement are issued by the RIMS. My lord, we both were appointed. According to them, my lord, in the seniority list, the name of the petitioner is below the respondent number 4. It is that their case.
When was that advertisement?
It was, my lord.
Where is the advertisement?
2012, my lord.
2012.
7/6/2012.
Page.
Page, my lord, annexure 1 to the counter affidavit filed by the respondent number 4.
Respondent number 4.
Page 22.
Just a minute, let me find out that first.
There are two counter affidavit by the respondent number 4, my lord. My lord, one has filed by the respondent number 3, showing themselves to be as a respondent number 4, my lord.
Let us see the advertisements. You are in which department?
My lord, anatomy, my lord.
Anatomy. And the respondent number 4 in which department?
Anatomy, my lord.
Both, same.
Seniority is to be in the same department, my lord.
Same department, anatomy. Associate professor, you are associate professor.
Lordship, this is for the associate professor.
Now let us see eligibility.
Yes, my lord. The second one is associate professor. MD so and so, 4 years teaching experience as assistant professor in the concerned subject with minimum of post MD, MS total teaching experience 7 years from the recognized medical college teaching institute.
What is the rule of interest seniority of direct recruits?
My lord, so far as the act of the RIMS is concerned, that your lordship will find, my lord, that did not mention about it, my lord. This simply says with respect to that part, I'll show, my lord, from the act itself. Section 11 of the RIMS Act, my lord, 2002. My lord, that.
So one thing is sure, you both are the employees of RIMS.
Yes, my lord. We are.
Yes, Mr. Just a minute. Mr. Anil Sinha?
Yes, my lord.
There is no doubt that you both are employees of RIMS.
Both, पता नहीं क्या इंस्ट्रक्शन को दे रहा है। कभी थे हम लोग स्टेट में। वो अटैच हुआ उसमें लिखा हुआ कि मेरे रूल एंड रेगुलेशन से आप गवर्न होइएगा। अपॉइंटमेंट लेटर दिखाइए ना इन लोग का।
So let me
see
what
is अपॉइंटमेंट। ये कहता है कि फुल प्लेजर है।
What is the seniority criteria?
Seniority में प्रॉब्लम क्या है?
My lord, at this junction.
No, just a minute. I'll hear Mr. Anil Kumar first. If you have to rebut.
Yes, my lord. I will wait for my turn.
Wait for your turn. Yes, RIMS Act, what does it say, Mr. Kumar?
Yes, my lord. I was submitting, my lord, section 11, my lord.
Yes.
It says, my lord, पदों पर नियुक्ति, मतलब शैक्षणिक संवर्ग के सभी पदों पर नियुक्ति खुले विज्ञापन तथा शैक्षणिक संवर्ग के पदों हेतु तो स्थायी चयन समिति द्वारा की गई अनुशंसा के आधार पर शासी परिषद द्वारा की जाएगी। मतलब दिस इज द RIMS अपॉइंटमेंट प्रोसीड्योर, मतलब so far as that part is concerned. But the शैक्षणिक संवर्ग, मतलब so far as the teaching cadre is concerned, that has not been defined in the act or any other executive order. Therefore, so far as this part is concerned, Lord, it is being treated, my lord, so far as the qualification is concerned with respect to the teaching post, my lord, is on the basis of the MCI that is being provided in subclause 2 itself. so far as the NCI qualification which is being prescribed by the NCI, that will be applicable to the teaching cadre. But you're not taking into consideration so far as the teaching cadre is concerned, that has not been defined. Therefore, it cannot be said, that how the interstate seniority is to be determined with respect to that part. No, nothing has been mentioned in that. There is absolutely nothing which is mentioned in the Act itself. Now, the counter affidavit which has been filed by the RIMS, my lord, your lordship, kindly see for a moment, my lord.
So on what basis you are claiming seniority?
My lord, my is, my lord, so far as the petitioner is concerned, my lord, prior to associate profession, she was seen.
Mr. Anil Kumar, I understand. If I am not wrong, Mr. Anil Kumar, if I am not wrong, you are claiming seniority on the basis of your previous employment.
State government.
State government in the state government you are senior. In the state government you are senior to the respondent number 4.
My lord, if your lordship kindly see, my lord, so far as the annexure A to the counter affidavit file. No, I am coming to the notification, my lord, with respect to the appointment, my lord.
Yes.
My lord, with respect to the appointment, your lordship kindly see, my lord, the appointment later is, my lord, 6/11/2012.
Annexure?
वही है ना?
Annexure?
Yes, I am coming to that. तुम रेट में नहीं लगाया?
नहीं रेट में
वही है ना?
हाँ, annexure C.
Yes, my lord, annexure A to the counter affidavit filed by the respondent number 3.
Respondent number 3.
Lordship.
This is the director which you had taken.
Lordship.
यहाँ पर भी तो धर्म
आइए सब हटाइए तो इतना आइए लगा तो फाइनल हियरिंग सुन रहे हैं आइए लगाने का कोई मतलब नहीं है कीपिंग ऑल द आइज मिस्टर सिंह अशोक सिंह
माय लॉर्ड
आप अभी खाली सुनते रहिए आप म्यूट होकर रहिए बहुत आवाज आ रहा है आपका हमारे से
हमारे से नहीं आ रहा होगा जो हम तो सब बंद कर दिए
आवाज का दरवाजा खोलने का ये बंद करने का कुछ चीज का yes
Yes, my lord, so far as this is the posting order, my lord, with to the post of associate professor, my lord. संस्थान में निम्नांकित पदस्थापित एवं कार्यरत चिकित्सकों ने अपने चयनित पद पर अपना योगदान उनके नाम के सम्मुख अंकित तिथि को दिए हैं। इन्हें अपने पूर्व पदस्थापित पद से स्वयं पे उनके योगदान को स्वीकृत किया जाता है। मतलब so far as the notification with respect to the appointment is concerned, मतलब they are to come that this is the notification on the basis of merit, my lord, the appointment has been made. If that is so, my lord, then definitely, my lord, the petitioner cannot claim with respect to that part. But my lord, the RIMS should come out.
No. The question which I had put to you is that you are claiming seniority on the basis of the seniority which was there in a previous employment.
Since the date of initial appointment.
In your previous appointment.
Lordship.
Okay, I've understood now. Mr. Singh.
May I submit, my lord?
Now tell me what is the criteria for fixing seniority in a direct appointments?
My lord, there is absolutely no doubt that both respondent number 4 and the petitioner belong to Jharkhand Health Service, initially deputed to RIMS on lien basis for there. But on 7th of June 2012, an advertisement was floated by RIMS, not for promotion. That's the point I want to make. Here, Mr. Sinha was very correct. The word is, let me read out. Applications with complete biodata are invited for filling up the under-mentioned post.
I have understood. The question which I am putting to you, how do you, in a direct recruitment, how do you fix seniority?
Exactly. That is regulated by RIMS Regulations 2014, Annexure 4, Appendix 4, Clause number 5, Seniority List. My lord has asked a very pertinent question, and that will solve the issue. I draw my lord's attention to Schedule 4, Clause 5, Seniority List. It says how seniority will be determined. May I read with Honorable Court's permission?
first let me get that document. Where is that document? देखिए schedule 4 कहाँ है? दीजिए.
वो डॉक्यूमेंट हुजूर ना पिटिशनर ने लगाया है, ना रिस्पोंडेंट ने लगाया है, ना रिजॉइंडर ने लगाया है.
क्या नियमावली 2002 ना
ये
अधिसूचना
हम
कौन
हुजूर
वाला?
पढ़ रहे हैं रीम्स रेगुलेशंस
नियमावली.
2000.
What are you trying?
My lord, I am reading Reams Regulations 2014
You are saying in
Schedule 4.
English, but all documents are in Hindi. What you are reading? अधिनियम पढ़ रहे हैं कि नियमावली पढ़ रहे हैं?
हम पढ़ रहे हैं रेगुलेशंस.
तो रेगुलेशन इज नियमावली.
2014 का नियमावली नहीं, उसका हुजूर हिंदी विनियमावली होता है, लेकिन हम रेगुलेशंस पढ़ रहे हैं 2014 को, जो 8 सितंबर 2014 को बना. इसके पढ़ने के बाद इस केस में कुछ डिसाइड करने को रह ही नहीं जाएगा. हुजूर के परमिशन से हमको पढ़ने दिया जाए, हम अनिल सिन्हा का सपोर्ट कर रहे हैं.
कंडीशन ऑफ सर्विस रेगुलेशन से होता है. कंडीशन ऑफ
फाइल कर दें
रेगुलेशन चलेगा.
माय लॉर्ड, हमको पढ़ने दिया जाए, उसका हम रिकॉर्ड पर फाइल कर देते हैं.
पढ़िएगा पहले, हम खोजेंगे, एक साथ पढ़ेंगे तब ना. हमको मिल ही नहीं रहा है क्या डॉक्यूमेंट है, आप पढ़ रहे हैं कहाँ है.
तो हुजूर हमको कल रख दिया जाए, आज फाइल कर देते हैं.
होगा, कल नहीं होगा. पेज 65 पेज का डॉक्यूमेंट है क्या? वो टोटल 65 पेजेस है.
ये डॉक्यूमेंट है टोटल नंबर ऑफ 65 पेजेस.
हाँ 65 पेजेस. लाइए ना, प्रिंट आउट नहीं चाहिए हमको, डॉक्यूमेंट दीजिए जितना पन्ना.
हुजूर वही डॉक्यूमेंट है 65 पेज वाला. उस डॉक्यूमेंट के हुजूर पेज नंबर 45.
कौन पेज में है? कितना पेज से कितना पेज तक है?
हुजूर 45 नंबर पेज पर आया जाए.
खाली 45 एक ही पेज में है.
एक पेज में खत्म. पेज 45 पर अनिल बाबू जीत जाएंगे.
Look, I have to. My office has to take a printout of it because it's not here. And I'm not carrying my laptop also.
पढ़े हुजूर की छोड़ दें, जो हुजूर का ऑर्डर.
Okay, just wait कीजिए. आपका
हम वेट कर रहे हैं हुजूर. हम ऑनरेबल कोर्ट का टाइम इसके.
Where is your picture?
My picture.
Yes. There's something problem with your video. Switch on your video. Yes.
अब थोड़ा थोड़ा फ्रीज कर जाता है थोड़ी देर के बाद.
Yes.
With honorable court's permission, I may be permitted to read the relevant para.
Yes,
seniority. Solve the issue, my lord. Please come to page 45 and Annexure 4, clause 5, my lord.
Yes, clause 5.
Seniority list. May I read, my lord, for my lord's convenience?
Yes.
This clause 1. The seniority of the employees of the institute in
Read from beginning. Read from very beginning. As per the rules in force.
My lord, may I read out?
Yes.
The seniority of the employees of the institute.
Mr. Singh, read from as per rules in force. You read from there.
As per the rules in force, there can be direct recruitment to all the grades of the faculty. इसमें हुआ direct recruitment to all grades of the faculty, and selection on each occasion could be for appointment to be made at the same time. जैसा इसमें हुआ, but in more than one discipline, the combined seniority list of the institute shall be worked out as follows. Clause 1. The seniority of the employees of the institute in each category shall be determined by the order of merit in which they were selected for appointment to the grade in question. Clear हो गया होगा जी? In order of merit, those हम फिर से पढ़ देते हैं हुजूर. The seniority of the employees of the institute in each category shall be determined by the order of merit.
Yes.
In which they were selected. So, yes. In a transaction in which direct recruitment is being made, the seniority, if appointed in reams, will be determined by the order of merit.
Where is the merit list?
Yes, please come to rejoinder, page number 32.
Rejoinder
of 4, page number 31 में हुजूर आए. Rejoinder of respondent number 4 का पेज 31 पर हुजूर आइए. हम अनिल बाबू को मदद कर रहे हैं, फीस वो ले गए हुजूर, हम पास उनका कर रहे हैं.
वो हम नहीं जानते. Rejoinder
31 पर आया जाए.
31 पर
31 पर हुजूर आइए.
हाँ भाई इस पेज ही नहीं दिया I don't have page 31.
काउंटर है respondent number 4 का counter.
Someone is saying rejoinder, someone is saying counter.
Counter affidavit of respondent number 4, page 31.
Page 31.
Yes, my lord.
Just a minute. Yes.
My lord, see, respondent number 4, Dharmendra Kumar, to marks obtained 67.4, my lord. Petitioner Kumari Sandhya, marks obtained 59.74, and that is the merit list.
Yes, Mr. Anil Kumar, what do you have to say?
अब तो हुजूर उनको बहस क्या करना है, उनका तो काम सब हमने बहस कर दिया हुजूर.
अनिल कुमार petitioner.
हाँ हुजूर सुन लिया, जब फीसवा तो वही ना लिया है.
Yes.
तो प्रॉब्लम हो रहा है साहब.
अरे हम लोग फ्री में थोड़े कर रहे हैं अशोक जी, आप भी ले रहे हैं, हम भी ले रहे हैं.
पर परेशान है आज.
Mr. Anil Babu चेहरा दिखा दिए, that is enough.
नहीं मान लिया हुजूर, देख लिया उनको, इतने बड़े अधिवक्ता है कि उनको देख के दिन बन जाता है.
He has justified his fees. अब बताइए. Yes, petitioner.
Yes, Lord. So far as my contention before your Lordship is concerned, my Lord, this is the internal document, my Lord. The notification which had been issued with respect to the appointment, my Lord, that is appointment. That is not the seniority list. No, I am saying that will show, my Lord, whether it has been done on the basis of the merit list or it is there itself. My Lord, that is not mentioned. This is the internal document which is mentioned.
That is not mentioned. That is not mentioned.
Then, my Lord, then what is to be seen, my Lord? That is my question, my Lord. That is my submission. Yes. That is my submission. This is the internal document for the purpose of determination, my Lord. What is to be seen? The notification which has been made public, my Lord.
Yes, definitely.
That has been brought on record. The joining letter has been given therein. This is my submission, my Lord.
Is it your case that you have not appeared for interview?
No, I am not saying, my Lord.
Heard the counsel for the petitioner, heard the counsel for
हुजूर
the
इन
state.
अक्सर 5 को देख लिया जाए, इनका क्वेश्चन का उत्तर मिल जाएगा.
Mr. Anil Kumar Sinha, learned senior advocate on behalf of respondent number 4. बोलिए Mr. Sinha.
हाँ बोल देते हैं हजूर. मान लीजिए रूल नहीं रहता, रेगुलेशन नहीं रहता, तब क्या होता? ये तो इन्हें के सीनियरिटी डिसाइड नहीं होता. तो जनरल प्रिंसिपल जो है वेरियस जजमेंट का कि व्हेन इट इज ए डायरेक्ट रिक्रूटमेंट, the merit list is the guiding factor for deciding intersectionality. Is it settled law by full bench विष्णुदेव कुमार सिन्हा केस? तो उसमें है नहीं, लेकिन आपको हम समझा ये है कि मार्क्स दिखा के और सेटिस्फाई कर दिए कि वो मेरिट लिस्ट में नीचे थे.
लिखिए. So the dispute lies in a very narrow compass. Next panel. The petitioner is claiming seniority over respondent number 4. Full stop. Next paragraph. The counsel for the petitioner, Mr. Anil Kumar, submits that both this petitioner and the respondent number 4 was in the services of the state, before they were appointed by writs. Full stop. He submits that under state, while they were in services under the state, this petitioner admittedly was senior to the respondent number 4.
ले जाकर ठीक कराओ, मेरा फोटो फ्रीज हो जाता है, रुक जाता है.
आपको देख के सब फ्रीज हो जाता है, इसलिए state. Full stop. He submits that pursuant to an advertisement issued by RIMS, this petitioner and respondent number 4 applied for appointment, and they were appointed by RIMS in the Department of Anatomy, and they joined on the same date, that is on 29/10/2012, in the post of assistant professor.
My Lord, associate professor.
Associate professor. First up, he submits that in the appointment letter, which is a combined appointment letter, the name of the respondent number 4
4.
has been shown at serial number 3, while that of respondent number 4 at serial number 2 and petitioner at serial number 3. He submits that the RIMS have taken the said arrangement to be the seniority and has proceeded accordingly. He submits that the seniority which was prevalent prior to joining of the joining at RIMS between the interstate seniority which was prevalent prior to joining of the petitioner and respondent number 4 at RIMS, while they were serving under the government, should be the guiding factor while deciding the issue of seniority. He submits that since the petitioner was senior to the respondent number 4 while they were serving under the government, the petitioner should be declared to be senior in RIMS also. Next paragraph. Mr. Ashok Kumar Singh, appearing on behalf of the RIMS, opposes the prayer. Mr. Ashok Kumar Singh and senior advocate Mr. Anil Kumar Sinha opposes the prayer of the petitioner and submitted that the seniority of the employees of RIMS is governed by किताब दीजिए इसका 45 से जहाँ से लिया 45 जहाँ से लिया क्या is governed by so and so rules. Full stop. He submits that after following a proper selection process, the petitioner and the respondent was appointed. Full stop. It is appointed. Full stop. An interview was conducted and marks were assigned to each of the candidates, and on basis of merit, the respondent number 4 was placed. Respondent number 4. Respondent number 4's seniority. Respondent number 3, the petitioner and the respondent number 4's seniority was fixed, and the respondent number 4 became senior by virtue of the marks obtained in the selection process. Full stop. It is submitted that the appointment which was made in RIMS pursuant to an advertisement is a fresh advertisement, and the seniority, inter-seniority of the petitioner and the respondents number 4, which was there under the state, cannot be carried forward in the new appointment. Next matter. After hearing the parties, I have gone through the records. Full stop. The fact that the petitioner and the respondent number 4, prior to joining at RIMS, were employee of the state government is not disputed. Full stop. It is also not disputed that the petitioner was senior to the respondent number 4 in the services of the state, in the services when they were under the state. Full stop. It is also not disputed that an advertisement was published by RIMS on 7/6/2012 to fill up the post of associate professor in the Department of Anatomy, along with several posts in several departments of RIMS. First, a fresh application was sought for to fill up the said post under RIMS, which is an autonomous institution under the government of Jharkhand. First up, the eligibility criteria and the conditions was set forth in the said Full stop. From the advertisement, it is clear that the appointment the appointment which was to be made to fill up the said posts were fresh appointments. Full stop. Build up. The petitioner and the petitioner and respondent number 4 applied and were appointed through a selection process. Full stop. The selection process, an interview was conducted and a merit list was prepared. Full stop. The fact that the interview was conducted is also not disputed by the petitioner or the respondent, nor by the RIMS. Full stop. The RIMS, in their counter affidavit, had annexed the mark sheet / merit list of the petitioner and the respondent number 4. First up, from the said merit list, I find that the petitioner was allotted 35.74 marks in academics, 24 marks in interview, totaling to 59.74. Full stop. The respondent number 4 was allotted 42.4 marks in academics and 25 marks in interview, totaling to 67.4. Full stop. Thus, the respondent number 4 obtained higher marks than that of the petitioner, which made him more meritorious than the than the petitioner for the purpose of appointment. Full stop. In the merit list, the respondent number 4 was placed in the first position. Full stop. Next paragraph. The Rajendra Ayurvigyan Sansthan Viniyam 2014 provides for fixation of seniority amongst the employees of the said institute. Regulation 5 deals with seniority. Full stop. It is necessary to quote the relevant regulation for this purpose. Quote. From the aforesaid provision of law, it is clear that in each category, the seniority will be determined in the order of merit in which they were selected for appointment to the said grade. Full stop. Admittedly, both the petitioners both the petitioner and the respondent number 4 are in the same grade. And from the merit list which has been annexed, it is clear that the petitioner was placed at, respondent number 4 was placed at number 1 in the merit list at the time of appointment, as he had obtained 67.4, whereas the petitioner was placed at serial number 2 in the merit list, as she obtained 59.74. Full stop. Thus, since the respondent number 4 was placed above the petitioner in the merit list, in terms of the aforesaid regulation, the respondent number 4 became senior to that of the petitioner. Full stop. Be it noted, both the appointment of the petitioner and the respondent number 4 were a fresh appointment in RIMS, and their seniority is to be governed by this regulation 5. Full stop. The their interstate seniority with their previous employer, that is the state, has lost its relevance once the petitioner and the respondent number 4 applied and were appointed by RIBS pursuant to a fresh advertisement. Now, the petitioner and the respondent number 4 are employees of RIMS and they are to be governed by the service condition of the RIMS and not that of by the state. So the seniority will be governed by the conditions laid down by RIMS and not by the state. First of thus, I find no illegality in the respondent number 4. I find no illegality whereby the respondent number 4 has been declared to be senior to the petitioner. Full stop. The claim of the petitioner that the petitioner is senior to that of respondent number 4 has got no merits. The specific application stands dismissed.
Obliged, my lord.
IA for early hearing.
Yes, my lord, that may be.
The IA number so and so, in view of the final order deciding the merits and issues involved in this writ application, this IA is dismissed.
Obliged, lordship.
Yes.
Serial number 25, WPS 5471 of 15, Mr. A.K. Sahan.
May please, Lordship. Note this relates to the non-issuance of appointment letter not in the year 2015. He approached this on court immediately, my lord.
Which
now, my lord,
post?
for the post of assistant teacher, my lord. Now, counter affidavit para 3, the grievance of the petitioner that pursuant to advertisement, he being qualified and having higher marks, but he was avoided, and in place of him, the lower marks were appointed. Now, the counter affidavit, they say in para 5, there are two counter affidavit. Counter affidavit filed by the respondent number 2 and 3. You'll see me kindly see for a moment.
2 and 3.
3 and 4. That is filed on 3/3/2016. Paragraph, only one paragraph. That is para 7.
Para 7. Yes.
They say that who have applicant oblique petitioners who have secured more than 69.51 has been selected in MBC category, such and such. There is no question to consider. Now they are not disclosing what is my marks. So what I have done, my prayer at the moment would be that the liberty may be given to pursue his representation made earlier. That is Annexer 7.
Representation.
Annexer 11.
Who is for the?
I am appearing on behalf of the state lordship. As per oral instruction, lordship, petitioner has obtained lordship 67.11% marks, lordship.
The MA, the point with regard to MA has not been taken into consideration. He is MA postgraduate degree, and the persons having graduation degree, even if the graduation degree 5 points is added. Therefore,
Lordship, if for
it
some
can
time
be
granted, then I will file a detailed counter
it
affidavit.
will be kept pending. I can pursue the.
Yes.
I can pursue the matter before the concerned authority. The respondent number 3.
No, not necessary. The matter is pending here since 2012. Let me decide this case. Next week, Mr. Ashok Singh.
Obliged, lordship.
Yes,
2 weeks, lordship. 2 weeks, lordship.
Petition comments that in the counter affidavit in paragraph 7, the respondents have stated that have asserted that the persons who have been appointed had obtained more marks than 69.51 in M, capital M, full stop, BC category. So the petitioner cannot be appointed, full stop. He submits that if the last candidate who has been appointed in the state category has obtained 69.51%, then what was the marks the petitioner has obtained has not been mentioned. Full stop. At this stage, Mr. Ashok Kumar Singh appearing on behalf of the state.
Yes, Lordship. State.
State prays for 2 weeks' time to file a short affidavit intimating this court the marks which the petitioner has obtained.
Yes.
Full stop. Prayer allowed, list this case after 2 weeks.
Much obliged, Lordship.
Serial number 27, MN number 303 of 19, Mr. Pratish Kumar, Mr. Prashant Kumar Srivastav.
Yes, Mr. Pratish.
Yes, my lords, if your lordships, as per the last order, my lords, we both parties were come ready with the exact amount which, because as per the defense which was taken, my lords, lordships was pleased to direct BCCL also.
I've called the wrong case. Serial number 26.
Serial number 26. Your case will come. This is serial number 26.
Mr. Ram Lakhan Yadav.
Where is Mr. Ram Lakhan Yadav? No one appears. List this case after 2 weeks. No one appears on behalf of the petitioner. Yes.
Yes, my lords, as per the last order, my lords, BCCL was also directed and the appellant insurance company was also directed to, my lords, come with the amount, exact amount which has to be deposited by the BCCL before the Registrar General, my lords. Lords, as per us, lords, the calculation is 27,23,638.
And as per Mr. Das?
Lordship, as per us, Lordship, there is a difference of few thousand rupees, your Lordships.
How much?
21 lakh 8,168 is the Lordship principal amount, and 6 lakhs 10,617.83 is the interest amount. Total amount will be, your Lordships, 27 lakh 18,785.83.
18,007?
85.83.
Okay, 786.
786, yes, Lordship.
Deposited by how much time?
Lordship, 4 weeks time, your Lordships.
No.
Lordship, the difficulty is, Lordship, my clients do not have the record of this case. Lordship, the copy was served. I filed the Vakalatam from the headquarters, Lordship, they could not trace out. Today morning, Lordship, I sent the award, then asked them to calculate.
So you have not appeared before the trial court?
No, we appeared. It appears they have appeared, but nobody was having the record.
Deposited within. I'm giving you an order.
Yes, yes, Lordship.
The insurance, the person to the last order.
Lords, the limitation needs to be condoned, lords.
Oh, limitation condone कर दीजिए. Delay condone. Pursuant to the last order, the counsel for the insurance company submits that the total amount along with interest comes to 27,23,638. Full stop. The counsel appearing on behalf of the owner of the vehicle submits that as per his client, the amount is 27,18,786. Full stop. Considering the submission, I direct Bharat Coking Coal Limited, that is the owner of the offending vehicle, to deposit 27,18,786 rupees before this court within 3 weeks, before the Registrar General within 3 weeks. Full stop. Who is for the claimant?
Lord, the notices has to go, Lord, sir.
Actually, in the meantime, insurance company may be directed to pay it to the claimant and file an affidavit over here instead of issuing notice. That was the only ground.
Okay. Before this court. Yes, insurance company.
Lord,
the insurance company is directed to satisfy the award within 3 weeks and file an affidavit to that effect before this court. You are safe now, Mr. Pratish Kumar. Your company, your interest is safeguarded.
Obliged, lords.
Deposit and inform.
And Lord, there is an application for stay of the execution case, Lord.
Where is the stay? You deposit it. Once you deposit it, you go before the executing court and pay it.
Yes, Lord.
Go before the executing court along with this order and pay it. And
Yes.
if the case closed and file an affidavit here, then I will direct the Registrar General to pay the amount to you.
Yes, my lords.
Yes.
Serial number 28, CMP number 228 of 20, Mr. Rajesh Kumar Mahata.
Lordship, this is for restoration of a second appeal, Your Lordship, dismissed in default, Your Lordship. There's a limitation of 160 days, Your Lordship.
Limitation filed?
Yes, Your Lordship, I have filed it, Your Lordship.
Issue notice. Issue notice to the respondent. Registered ordinary.
As Your Lordship please.
3 weeks.
Respondent number 2, I am appearing, Your Lordship, BCCL.
That means it will go to
1 and 3.
2 and 3, Mr. You are appearing, Mr. Amit Dalike. Issue notice number 1.
2 and 3 is appearing, Your Lordship.
No, 2 only. Yeah, 2 and 3 I am appearing. Yes, Lordship. 1 and 4 notice will go.
Issue notice to respondent number 1 and respondent number 4. Registered ordinary 3 weeks, full stop. Requisite 3 weeks. Next para, Mr. Amit Das is appearing on behalf of respondent number 2 and 3.
All right, Lord.
Serial number 29, CMP number 423 of 20, Mr. Ahilya Mahato.
My lord, restoration of second appeal, my lord, 472 of 16. There is limitation, my lord. I have filed the limitation petition also.
Notice.
4 to 8, my lord. Respondent opposite party number 4 to 8.
4 to 8. Why? What about the rest? State?
Rest is state, my lord.
Okay.
Your Lordship, I am appearing on behalf of the state, Your Lordship. Diva Tantra, SC Mansuman.
Notice 4 to 8 registered and ordinary requisites 4 weeks.
Lordship.
Serial number 30, contempt civil 705 of 20.
My lord, the orders have been complied. I have filed a so stating the full payments have been made.
Pursuant to last order,
Order complied or not?
Complied.
They have filed SOCOs.
Just tell me order complied or not, yes or no?
As is stated, some amount has been paid, but as per my information, HRA and MA has not been paid. So, liberty may be given.
I have heard the counsel for the parties, full stop. An affidavit has been filed showing compliance of the order passed by this court in CRF in writ application number so and so. Next para. The counsel appearing on behalf of the petitioner submits that some portion of the claim remains to be paid. Full stop. Next para. Considering the aforesaid fact, I am of this opinion that no contempt is made out. This is not a case where contempt, this court should proceed for committing contempt against the. This court can proceed against respondent number so and so for committing contempt. Full stop. This contempt application is dropped. The proceeding is dropped. Full stop. This application is disposed of. Full stop. It is made clear if the petitioner has got any grievance, he may approach the appropriate authority. Any further grievance?
Obliged, my lord.
Yes.
Obliged, my lord.
Under the heading fresh filing, serial number 31, WPC 4822 of 14, Mr. Rupesh Singh, Mr. Aurangzeb for petitioners.
My lord, in this case, my senior friend, Mr. Rajesh Kumar, will be appearing, but his name was not indicated. I have informed him. He's also connected.
I am appearing, my lord. My friend just now informed me, and due to his endeavor, my lord, I am here before lordship.
What is this?
My lord, this is a case where the petitioner had obtained a housing loan at the rate of 7.75%. And my lord, all of a sudden in the year 2011-12, amount of 75,000 and odd was extracted from his account because there was an electronic transfer system, my lord, for payment of the EMI. When the petitioner approached the respondent, my lord, Annexure 3, they said that as per the system, my lord, may kindly come to page 33 of the writ petition.
33.
Yes, my lord, page number 33.
Yes.
Para 2, my lord, I am reading. Kindly refer to paragraph 3 of arrangement letter dated 3/10/2005 provided to you. Housing loan was sanctioned with concessionary fixed interest rate of 7.75% with the condition that in the event of default in payment or any irregularity in account, the bank reserves the right to levy a higher rate of interest as it deems fit. Then, my lord,
just a minute. Where are you reading? Annexure 3.
Annexure 3, page 33, second paragraph.
3. Okay. Yes.
Kindly refer to the paragraph number 3. That is what I am reading.
Yes.
Of the arrangement letter dated 3/10/2005 provided to you, housing loan was sanctioned with concessionary fixed interest rate of 7.75% with the condition that in the event of default in payment or any irregularity in account, the bank reserves the right to levy higher rate of interest as it deems fit. My lord, para 3, based on your repayment/default history, our system has increased the rate in the year January 2011. We sincerely regret the inconvenience. My lord, may kindly note this aspect. We sincerely regret the inconvenience caused to you and we request you to kindly pay the increased EMI regularly to avoid penalty as per the instructions of the bank. Now, my lord, when this document is, my lord, read with.
Come to paragraph 3 of the arrangement letter. Where is that arrangement letter?
Annexure 1, my lord, page 27.
Yes, paragraph 3.
Rate of interest.
Yes, rate of interest.
Fixed rate of interest. Interest on the loan will be charged at 7.75% per annum on highest monthly reducing balance at quarterly rests. In the event of default in payment or any irregularity in account, the bank reserves the right to levy a higher rate of interest as it deems fit. So this is, my lord, what is
this condition? An open-ended condition, you can charge 100%, 500%, 300% also? Bank?
My lord, for this same thing, my lord, they moved the ombudsman, my lord.
Yes.
I was coming to that, my lord.
And ombudsman order is there, my lord, at annexure by way of annexure 5/1, page 39.
Just give me a simple answer. We levy a higher rate of interest as it deem fit. What is this as it deem fit?
My lord, will just have a look to annexure 4/2, page 37, my lord.
Yes, 4/2, page 37. Yes.
There, my lord, will find the explanation, my lord.
Yes, my lord. May I place this, my lord? 4/2, page 37.
37. Yes, 37.
This is 37 dated 29/1/2014, 28/1/2014.
Yes, 37.
Yes, my lord. We refer to your complaint lodged with the banking ombudsman on the above. In this regard, we have to advise as under. Interest rate applied in the captioned loan account is in accordance with the bank's extant instructions. So, my lord, in Annexure 3, the reason being, my lord, indicated and then regretted by them is the payment/default history. And here the reason is in accordance with the bank's extant instructions. Rate of interest to be applied in your account with effect from 3/10/11 should be 12.50%, against which only 9.75% interest is being applied in your home loan account, which needs to be corrected. This is a veiled threat, my lord. Then, however, we would also like you to request you to opt for one-time switch over to standard floating rate by paying 0.56% of the outstanding as one-time upfront fee. The standing floating rate at present is 10.15%. So, my lord, in Annexure 3, they say that as per the system, and they regret the inconvenience. In Annexure 4/2, they say as per the bank's extant rules, and then by extending a veiled threat, they asked me to make payment of one-time upfront fee and then to come to a floating rate of interest. Otherwise, my rate of interest will be increased.
This is immaterial. Address on the one.
And
then,
my lord.
Also, listen to me first.
My lord.
These are all subsidiary issues. Have got nothing to do with the money. Listen to a question which I am putting to you both.
My lord.
You applied for a loan.
Yes, my lord.
The bank accepted, and there was an agreement between the parties. This is an agreement.
My lord.
This is an agreement.
My lord.
Now show me whether this clause, this part of the clause in the agreement, that in case of irregularity and default, up to here it is no problem. The bank reserves the right to levy a higher rate of interest as it deems fit, whether this clause is a reasonable clause or not, without putting what would be the amount or the rate of interest. Whether there was any agreement that in case of default, the 7.5% will be increased to A, B, C, X, Y, Z, or as per a circular of the bank dated so and so. Whether is this given, whether this clause can be simply reasonable. Address on this issue.
Milord, there was no
a clause in the agreement which is vague, which does not specify anything specifically, whether that clause can be given effect to.
Milord, that to the extent of Milord, to the extent of ambiguity, Milord, it cannot be read as a lawful Milord condition.
Show me the judgment. Show me any judgment.
Milord, judgment will take some time, Milord. May kindly pass over.
The only issue which is to be decided. Yes, Mr. Rajesh.
I'm sorry.
My lord, in my view, my lord, it is as per the agreement, my lord, and the ombudsman order, my lord, has not seen page 39.
Ombudsman order is at page
39, my lord.
39.
I was just checking, my lord, by annexure 5/1.
Read that.
My lord, page 39, my lord. Para 2 I am reading before lordship, my lord, for my lord's kind consideration.
Yes, yes.
इस संबंध में बैंक से प्राप्त जानकारी के अनुसार प्राप्ति संलग्न जिस पर समीक्षा बैंकिंग लोकपाल के द्वारा सावधानी पूर्वक की गई, अब पाया कि भारतीय स्टेट बैंक के विरुद्ध आपके आरोप सही नहीं है, अतः बैंकिंग लोकपाल द्वारा आपके शिकायत की योजना को खंड 13 के अंतर्गत बंद कर दिया जाता है. And then, my lord, in last line it is observed, if you want, you are free to go to civil court because there is agreement.
Yes. Now tell me whether this is an agreement. You also admit, Mr. Rajesh Kumar?
My lord.
Whether this vague clause can be given effect to.
My lord, that, my lord, has to be seen because the agreement has been there, my lord.
If you come with an agreement that if you do a particular act, if you don't do a particular act, I will do whatever I like. Is this an agreement?
Agreement is not before lordship, my lord.
This is an agreement. Annexure 21 is an agreement. This is an agreement, arrangement letter. This is the final document. This is an agreement. This is the acceptance of the offer. This finalizes the agreement.
The agreement is not before lordship, my lord.
This is the agreement.
Annexure 1.
Yes. This is the
That is the arrangement.
So this is the arrangement means as it deals with
arrangement is on that is under challenge.
Show me any document which bears your signature and his signature, which says that in case of default.
Then let me file counter affidavit, my lord. Let me file counter affidavit. I will introduce the agreement itself.
Yes. The bank is directed to file a counter affidavit stating specifically whether there is any agreement specifying the rate of interest over and above 7.5%.
7.5%. 7.75.
Over and above 7.75% in case of default made by the petitioner in paying the regular payments. Right. You come up with judgment, Mr. Rupesh Kumar, not like this.
Yes, my lord, surely, my lord, definitely, my lord.
My lord has granted 4 weeks time.
4 weeks.
Let it be after 6 weeks, my lord, because Dhanbad, but the branches must have changed.
6 weeks, 6 weeks.
Obliged.
Under the heading for admission, serial number 32, WPS 7596 of 2006, Mr. Gauridas, Mr. Sandeep Kumar Chandra, Ms. R. Ms. Sujata Madanyarji.
Who is appearing? Who is appearing? Who is for the respondent? Yes. Who is for the respondent?
Name of Mr. Rajesh Kumar, Mr. Abhijit Kumar Singh, Mr. Shyam Krishna Sahai, Ms. Sheila Prasad appears for the respondent.
It was from the office of the then GP5, my lord.
Say, I understand now. Now who will appear? Who is for the petitioner? Again, no one appears on behalf of the petitioner. Similarly, none appears on behalf of the respondents. We'll stop to give one more opportunity. Let this case be listed after 3 weeks. When the court hears the matter in physical mode, matters in physical cases in physical mode.
Serial number 33, WPS 4587 of 2007, Mr. Rajiv Sinha, Mr. B.K. Prasad.
Yes.
Yes, may I please, Lord?
Yes.
My lord, in this case, the petitioner has asked for salary to be paid to the petitioner.
Yes.
It has been illegally withheld on the pretext of Annexure 7.
Annexure 7?
Yes, my lord. Please. The whole issue is, my lord, that they say that the appointment of these petitioners were illegal and not in accordance to law, therefore they are not entitled. But prior to that, already there was a complaint and criminal case filed in which these petitioners on the same allegation.
Mr. Sinha, please read Annexure 7.
Yes. उपयुक्त विशाखिन ग्रामीण जनता पकुड़िया के द्वारा जन शिकायत पर अध्यक्ष मदरसा इस्लामिया मजरूर उलूम पकुड़िया ने अध्यक्ष को लिखित सूचना दी है कि आपके मदरसे में काजरत मोहम्मद जहूर इलाम पेशर सो फर्जी प्रमाण पत्र के आधार पर वेतन के रूप में सरकारी राशि प्राप्त कर रहे हैं। अतः दोनों शिक्षकों की सभी मूल प्रमाण पत्र पुस्तिका नियुक्ति पत्र प्रस्ताव की मूल प्रति के साथ दिनांक इतना अध्यक्षारी के कार्यालय में उपस्थित हों ताकि मामले की छानबीन की जा सके। निर्धारित तिथि में प्रधान मौलवी के साथ दोनों शिक्षक की उपस्थिति हो। And then by lecture 9, I appeared and gave my detail, Lord, page 54, representation.
What happened thereafter in the inquiry?
Nothing, Lord. What has happened? Let me give you a background, Lord. Similar complaint was made by public, and then there was an FIR lodged against PST. Kindly come to page and share 1, Lord. There was clean acquittal in that criminal case. Thereafter, again, the Madrasa board, they approached the secretary, Milord Madrasa, and then the appointment of the petitioners was declared to be illegal, against which an appeal was preferred by these persons, by Annexure 2 philosophy, page 32.
Page 32?
Annexure.
Yes.
And if Lordship will see, come to last paragraph, after discussing the whole issue about their date of appointment, the last paragraph at page 45, उपरोक्त तथ्यों के संदर्भ में अपीलार्थी की अपील स्वीकृत की जाती है तथा प्रत्यार्थी का दावा अविधेयक किया जाता है। अपीलार्थी संख्या 1 तथा
How do I know who are the appellants here and read the name?
these petitioners, my lord, and there were 7 teachers out of that. These are all admitted fact, my lord. Then they went in appeal also.
No, come in page 32. You're reading page 32, Annexure 2?
Yes, yes.
इस अपील के अंतिम सुनाई इतना को हुई। उक्त अपील मोहम्मद इस्लाम अली,
that is the secretary,
और मोहम्मद दिलजान अली,
अपील करता के ने अध्यक्ष और सचिव
मदरसा बोर्ड
मोहम्मद असुद्दीन, गुलाम रसूल, बाबरजन अब्दुल सादिक।
So this is appeal is not by you.
आलम प्रत्याशी के विरुद्ध दायर किया दोनों। The petitioner number 3, my lord, Islam Ali, if you lordship see petitioner number 3. He is Islam Ali. He is the secretary, my lord, of this.
So this is the managing committee. This is the managing.
Yes, represented through the secretary. Managing committee appealed against the decision of the board. The managing committee appealed against the decision of the board, and the managing committee has the right to appeal, and they appealed, and this appeal was allowed with respect to 5 persons, and they say that आप इनकी भुगतान की जाएगी। उपदत्त
Read the where is the name of this petitioner comes? The other 2 petitioners.
Lord, just to cut short the matter, my lord.
Yes.
I appear on behalf of the state, my lord.
Yes.
Lord, the same set of petitioners, my lord, they had approached this honorable court in another writ petition, that is WPS number 2251 of 2008, my lord. And by order dated 20th of November 2009, a coordinate bench of this honorable court was pleased to hold that the appointment of these 2 petitioners was illegal, and since the appointment was fraudulent, therefore the fraud this year's all solemn procedures, therefore they are not entitled for the.
What is the judgment?
That is, that judgment is at Annexure A to the counter affidavit by the respondent number 4.
That
is
4. I am appearing
yes,
on behalf of respondent number 4, my lords. Annexure A at page 12, my lords. The relevant is at page 13, my lords, para 3.
Same petition.
Just a minute, Mr. Ahmed. Manzar Alam and Zahur Alam.
Yes, my lord. Here the petitioner number 1 is Manzar Alam and 2 is Zahur Alam.
Yes, my lord.
Yes, Mr. Sinha. What about what?
Yes.
Now,
my lord, after this, what happened that the board went in, filed a writ petition, some persons, and that is Annexure 3.
No, you come to Annexure A to the counter affidavit of respondent number 4.
I'm coming, bro. Let me first place my case. I'll deal with all those things.
Yes.
So what happened that after even they were approved the High Court, then entire payments were made and regulatory payments were being made. Now, in 2006, again the same thing was raised by that Annexure 7, which I have read here also. And by Annexure 9, we brought everything. So that order attained the finality, so far by appointment is concerned. And the same type of allegations, same everything. Now we said that this Muhammad, if you also will see, Ibadur Rahman is respondent number 4. Ibadur Rahman. Now, Ibadur Rahman was dismissed by the managing committee.
Okay.
And Ibadur Rahman was dismissed, and thereafter he filed a writ petition. The writ petition was dismissed. They filed an LPA. Those orders I have annexed 10 and 11. The LPA was also dismissed. Subsequently, we went to a Apex Court, and Apex Court also they lost. So what my contention is that Ibadur Rahman is a non-entity person, but if your lordship will see Annexure 7, because this is how things have happened in Madrasa. Annexure 7, if your lordship once again see,
Yes.
They have said what in Annexure 7 is निर्धारित तिथि को प्रधान मौलवी के साथ तो दोनों शिक्षक की उपस्थित करेंगे. Now the Pradhan Maulvi was this respondent number 4. So we had an objection that he is a dismissed Pradhan Maulvi. You cannot do anything. And when the DO read, we wrote to the DO that how you are entrusting everything to him. Because in terms of payment, so for payment of the madrasa teachers are concerned, the Pradhan Maulvi has to prepare a bill, prepare it with the DO, and then the DO has to pass the bill. So that objection was raised, but the horse that now they have kept the pending, and now in the counter affidavit, we also will see. I come back. The same allegation, same thing is being written, which has already been put to rest by the judicial pronouncements. Now come to paragraph 6 and 7. They talk. Now, this is established in the year 73. The petitioner Manzar Alam was appointed in general body meeting held on Itna on the assumption. Now, these are the findings given by the appellate district Madrasa board secretary, which is upheld by the High Court. Has not passed matriculation. Manzar Alam has passed matriculation examination in Itna. Then the petitioner to Mazhur Alam was appointed general body meeting on Itna. And then they talk about the complaint. That the Bihar State Medical Board, Patna, was taken over in 78-11. And then they finally say that there is a complaint, therefore, then para 15, which will also come to the counter. The state of Jharkhand has not constituted Madrasa board separately. However, the works of Madrasa temporarily looked after by Jharkhand Ranchi. Approval of the newly constituted committee of the Madrasa headed by secretary has not been approved as yet. That Muhammad Madara is permanently absent from the Madrasa and Zohar permanently absent from the Madrasa. Then in para 17, they say that Madrasa Islam Madhur Pakudia has conducted an important meeting on Itna in which 9 members were present, including the president and secretary of the Madrasa, and they were meeting. Committee has dismissed Mohammed due to the negligence of the duty, illegal appointment, having no requisite qualification. So again, they have dismissed on the same very ground, which was earlier dismissed, set aside. Then they approached the High Court. The appellate authority has upheld my appointment. Now, whether it can go on endlessly, they are referring to this that they have been.
When did the appellate authority uphold your appointment? The date?
That Annex 2, Lord.
Date?
That is on 87. 17/1/87. Do they say that this is wrong? There is no whisper in the counter affidavit. Then I said that this order was filed, attested in the High Court in the writ petition, which is Annex 3. And then there it was withdrawn.
It was withdrawn.
Yes. And I was made payment. I was continuously being made payment. Now in 2006, again, there was a complaint that their appointment is forced. And then the same very ground, they again started this. And because we had this management committee had dismissed Abadur Rahman, the whole thing is being looking in this malign manner. And now what is their counter affidavit? The same thing. The counter affidavit is nothing new. That their appointment is illegal, therefore we have dismissed it. But how you say that appointment is illegal when there is already an order passed by a statutory appellate board, upheld, you went in the appeal, the appeal, the High Court, you withdraw it. The Abadur Rahman, respondent for whom the management committee dismissed, went up to Apex Court. Then you are directing him that you produce the bill. Therefore, the whole issue is that because my appointment is illegal, according to them, I'm not entitled to salary, I'm not entitled to perform. Now, this has to be justified. They have not replied anything on those 2 annexures. The appellate authority statutory appeal in which the order Annex 2 was passed, then subsequently they appealed before the High Court. There is no whisper on those facts. They have completely bypassed, because if they answer that, then I have a case. Let them point out from their counter affidavit. Supplementary counter, again they have followed, again the same thing they are saying. So let them show from any of their averment that yes, the appellate authority was order was the statutory appeal was order was set aside. They had not approached the High Court. The High Court had not passed any order. Ibadur Rahman was not dismissed, and that was upheld by this court. Appeal in LPA went up to Apex Court. That's my grievance. So why? What is the authority they have? So far, dismissal is concerned, the DO has no power. That's well settled. The managing committee deals with everything. The DO cannot recognize anything except that the management is in accordance to law. Therefore, my submission is that if my appointment was initially in 84 held to be illegal, which was set aside by the appellate authority, statutory appellate authority, and then the High Court, you go and you withdraw the writ petition, whether they can again re-agitate that ground on the same very basis. If they cannot, then I'm entitled to hold my areas of salary. That is the answer to be given by them. But they have not said that. They can only answer that if they say that those appellate authorities' order are not bad in law. But how will they say that until they don't get it set aside? And they have not disputed any fact, my lord. No such facts are but disputed. Only saying that the new management committee came and they have dismissed him. On what ground? That your appointment is illegal. Well, how I am illegal? Illegally appointment. When already the statutory bodies and the courts have declared. Even the criminal case, I got an acquittal. The criminal case also, the entire narration is that my appointment is illegal. How? They failed to prove there. Then the board dismissed me. Then I went in appeal set aside. So let them answer whether those documents, pleadings are wrong. If those pleadings are wrong, then I'm out. But if my appointment has been held to be legal times back, it cannot be go on reopening after reopening. And that too on the same ground. That's barred. That's my submission, bro. And there is nothing in the counter except that the management committee had dismissed him because his appointment was illegal.
Yes.
If you also will see my pleading, I come to my pleading, Lord. Kindly see my pleading, Lord, where they have answered these questions. Lord, kindly come to paragraph 4 and 5.
Yes.
Para 5, I'm saying.
Yes.
That it so happened in the 4, I am saying that madrasa was established in the year 73, was taken over by government in the year 78. Names of above mentioned teachers along with others were approved by Madrasa Education Board. The payment of said teachers was since approved after due verification of the certificates and credentials since 81 and continued service till March 2006 on novelty of grant by the government. That it so happened in the year 81 that some persons with vested interest filed a complaint on the allegations that petitioner and some other teachers have indulged in getting forced appointment by using forced certificate. In the said criminal case bearing so and so, TR number itna, the petitioner made accused and by judgment that itna, the petitioner given clean acquittal. That even prior to the said judgment, the Madrasa Board, by its order dated 4/12/84, had declared the appointment of the petitioner 1-2 as illegal and further directed for recovery of salary paid to them. The petitioner preferred an appeal, went in statutory appeal, bearing appeal number 6 of 81 before the Special Director Secondary Education Bihar Patna. Again, the said order dated itna of the Madrasa Board, the said appellate authority in its order dated itna held after giving detailed order that the appointment of petitioner 1-2 was made by management committee and the first payment of the salary was done only after verification of the certificate and register of the Madrasa by the Subdivisional Education Officer Pakur, and as such their appointment cannot be doubted. The appellate further directed the board to make the payment of due salary to petitioner 1-2 and others immediately. The board thereafter released all the payments and the petitioner 1-2 have contribution being paid their salary. It is further relevant to point out that against the said order, the appellate authority dated itna, a writ petition bearing so and so was filed and the same was dismissed as withdrawn by the order dated now. That as such, the validity of point of 1 2 have been upheld by aforementioned order passed by competent authority and court, which has attained finality and cannot be questioned anywhere. Now, there is no reply to these paragraphs in the entire counter evidence. There is no reply. Then I have in para 8, I have said that how the bills are to be prepared and sent to the district education officer. Then the petitioner number 3 issued a show cause to us. And then I have talked about respondent number 4, Ibadur Rahman, how we have dismissed him by annexure 5. We had dismissed, the managing committee had dismissed. And thereafter, there is no reply to all these facts, bro. They say that my appointment is illegal because in 73 the matriculation is this. I am a trained matric trained, which has already been concluded. And just to show that how in vengeance they have passed this order, the Abadur Rahman, who has been dismissed, who had approached this court, he lost in writ petition, approached the LPA, we had dismissed, then went to FS court. That was still they are going through them, and he is producing the bill. But anyway, I'm not concerned that the lookout of the board, they do it, but I am concerned about my salary. And in the counter affidavit, I have already read, there is no whisper of those paragraphs where I have asserted my claim over the salary. That's all, Mr.
Have you preferred any LPA against the order dated WPS 2251 of 2008?
WPS?
2251 of 2008.
It was dismissed.
Have you preferred any
LPA?
LPA?
He's asking if we have preferred LP or not. That was dismissed. Right? 2251.
What is the order?
Order nahi niकला ना. There is no order uploaded.
When what? Blood. Where is 225?
2251 of 2008.
Lord, that I am not aware about that. Lord. Even that order, I am not aware. This is what I am being instructed by my junior.
You are not aware, means
they have that order on.
Mr. Rajiv Sinha may not be aware. Mr. Rajiv Sinha is not aware.
Yes, yes.
Mr. Rajiv Sinha may not be aware. But the petition
Now, 7 matter, I have, because it is.
No, there's some other lawyer was appearing.
The petitioner might, but I am not in touch.
Some other lawyer was
Maybe
appearing.
that's why I am not aware about it, Lord. Otherwise, I would have dealt with that.
Yes, I've heard your
I am not in contact with the client.
I've heard your arguments.
At least if I had appeared, I would have.
Yes. This application is dismissed. Order to follow.
Yes. That is not the very client. What is.
Obliging notes.
Yes.
Serial number 34, WPS 4769 of 2007. Dr. H. Morris, Mr. M.I. Khan, for the petitioner.
May I please, Your Lordship?
Yes.
Milords, by this writ, Milords, writ petition, Milords, petitioner prays for quashing Annexer 7, Milords, that is University Notification, Milords, whereby and whereunder B.Ed certificates of petitioner along with various other persons, Milords, who were the students of Muslim minority Ahmadiyya B.Ed College, Katihar, Bihar, Milords, cancelled. Milords, thereafter, Milords, petitioners of various petitioners of Bihar, Milords, moved against that notification, Milords. Their writ petition dismissed, Milords, whereby they have also filed, Milords, LPA. Those LPAs were allowed, Milords. I have annexed the order at Annexer 8, Milords. Milords, thereafter, the state of Bihar filed SLP, Milords, before the Honorable the Supreme Court, Milords. This is the short facts, Milords. Milords, I have qualified JPSC for appointment primary trained teachers. Milords, I have duly been selected, Milords. My name appeared in the selection list, Milords. But I was not appointed as because this Annexure 7 university notification. Milords, thereafter, Milords,
Just a minute, read Annexure 7 first.
मिलर्स ये क्वेश्चन ऑलरेडी हो चुका है मिलर्स
पेज
पेज पेज 48
48 is the no the university notification. Page 48 is not the university notification.
Page 45 Milords.
Page 45 I'm sorry मिलर्स अधिसूचना
read that.
भूपेंद्र नारायण मंडल विश्वविद्यालय लालू नगर मधेपुरा मंत्रिमंडल निगरानी विभाग अन्वेषण ब्यूरो बिहार सरकार पटना से प्राप्त पत्रांक सचन सच 45/2000 एवं निगरानी थाना पटना में दायर मुकदमा प्राथमिकी संख्या सचन सच दिनांक 3/5/2000 के आलोक में कुलाधिपति सह महामहिम राज्यपाल बिहार के निर्देशानुसार निगरानी विभाग द्वारा की गई जांच के आधार पर यह सूचित किया गया है कि मुस्लिम माइनॉरिटी अहमदिया B.Ed कॉलेज मिल्लत नगर रामपाड़ा कटिहार को बिहार राजकीय शारीरिक शिक्षक प्रशिक्षण महाविद्यालय तथा राजकीय शिक्षक प्रशिक्षण महाविद्यालय एवं राजकीय प्राथमिक शिक्षक प्रशिक्षण महाविद्यालय नियंत्रण एवं विनियम अधिनियम 1982 बिहार विश्वविद्यालय अधिनियम 1976 एवं राष्ट्रीय अध्यापक शिक्षा परिषद NCTE अधिनियम 1993 के प्रावधानों के प्रतिकूल तथा साजिशापूर्वक एवं अवैध रूप से संबंधन प्राप्त किया गया है तथा उक्त संस्था को फर्जी मानते हुए इस महाविद्यालय के सभी छात्र छात्राओं को इस विश्वविद्यालय द्वारा दी गई B.Ed की डिग्री उपाधि को अनियमित एवं अवैध होने के आधार पर रद्द करने की अनुशंसा अनुरोध किया गया है। कुलपति महोदय द्वारा की गई जांच आधार पर भी उक्त तथ्य सही पाए गए हैं। तदनुसार संबंधित सभी व्यक्तियों को सूचित किया जाता है कि अपर महानिदेशक मंत्रिमंडल निगरानी विभाग बिहार सरकार पटना से प्राप्त पत्रांक 181 दिनांक 4/5/2000 के आलोक में तथा बिहार विश्वविद्यालय अधिनियम 1978 की धारा 10(11) एवं 10 सब धारा 2 में प्रदत्त अधिकारों का प्रयोग करते हुए तथा विश्वविद्यालय परिषद अभिषद आदि की स्वीकृति की प्रत्याशा में मुस्लिम माइनॉरिटी अहमदिया B.Ed कॉलेज मिल्लत नगर रामपाड़ा कटिहार का इस विश्वविद्यालय द्वारा निर्गत समन्वय संबंधी सभी पत्र आदेश वापस लिए जाते हैं, भूत लक्ष्य प्रभाव से निरस्त किया जाता है तथा उक्त B.Ed कॉलेज के सभी छात्र छात्राओं को इस विश्वविद्यालय द्वारा प्रदान की गई B.Ed की परीक्षा संबंधी सभी डिग्री प्रमाण पत्र अंक पत्र आदि कुलपति महोदय द्वारा रद्द करने की कृपा की गई। तो हुजूर ये मेरा सेट हम भी यहीं से B.Ed किए हैं। दैट वाज कैंसिल मिलॉर्ड्स देयर आफ्टर in LPA number in LPA milords annexure 8 this notification has been cancelled milords so far as it relates to the petitioners of that LPA milords milords against that LPA
no let me see where it has been cancelled
page annexure relevant page 78 relevant page May I read your lordship?
Let me see.
78, really.
Page 78.
Me lords.
Well, which position? Let's see.
First paragraph से पढ़ते हो
Huh.
It is seen above that the university was obliged to hold examination for the students of the college of the session 1999-2000. Hence, in order to cure the anomaly, the degrees granted to the students of the college for the past session must also be restored. The government order and the university notification bearing number GSA 700 ब्रैकेट में डैश VCO 615/2000 डेटेड 19/5/2000, ये अनेक्सर 7 है हुजूर। अनेक्सर 14 वहां था, CWC नंबर इतना, are accordingly quashed only in so far those direct for the cancellation of the degrees granted to the appellants in these appeals, Millers. So this order is for the appellants of those LPA millers. I am not there in those LPA millers. Therefore, I come before this honorable fort.
You are a fence sitter.
Millers?
You are a fence sitter waiting for the judgments.
नहीं मिलर्स, ये तुरंत हमने फाइल किया, देख लिया जाए, मेरा रिप्रेजेंटेशन देखा जाए, मेरा सब कुछ देखा जाए।
2000 and the LPA is dated.
ये LPA जो है हुजूर, इसका डेट है पासिंग का मिलर्स 2007, और हमारा रिप्रेजेंटेशन वगैरह सब कुछ झारखंड गवर्नमेंट में पड़ा हुआ है।
No, I am not on that. I am that this is the 2000 application. This is 5/2000. It was quashed.
मिलर्स 2007 में क्वाश हुआ हुजूर।
हाँ,
2007 में क्वाश हुआ।
7 में क्वाश हुआ है।
जी जी हुजूर, लास्ट पेज देखा जाए 79।
79, yes.
डेट दिया हुआ है
January 2007.
मिलर्स।
And you have also filed this in 2007. Yes, state, what do you have to say?
Thereafter, let me Millers,
in this case,
thereafter, Mr. Waris?
Thereafter, a state of Bihar went to the Supreme Court, Millers. Supreme Court, your lordship, this honorable court was pleased to direct me to file the Supreme Court judgment, Millers. Today, I have filed through email, Millers, and the Supreme.
Read the Supreme Court judgment.
Millers, paragraph 2 में यही है हुजूर। These appeals arise out of the common order dated 5/1/2007, वही annexer 7, passed by a division bench of judicature at Patna, whereby a batch of writ appeals filed by the respondents before the High Court have been allowed, and an order dated 28/3/2001 passed by the learned single judge, besides a notification dated 19/5 इतना, यही annexer 7 है, issued by the university set aside. Honorable Supreme Court इस पर कोई इंटरफेयर नहीं किया है, but Honorable Supreme Court has requested the Honorable Lokayukt of Bihar to hold an inquiry, Millers. The relevant page is at.
Show me the order.
Millers.
Show me the order.
Millers. पेज नंबर हुजूर, पेज नंबर 9 में आ जाए, पेज नंबर 9 हुजूर।
Just a minute. You have sent it by email?
Yes, my lords, today.
Let me take out the orders and judgments.
Today, Huzur.
ये जुम्मे दिन आता है आप लोग का।
हाँ उधर ही कोट पड़ा है, सिग्नेचर करा दीजिए ना।
No, there is no way. You have sent it in which mail, Mr. Boris?
Milords.
Which mail?
झारखंड हाई कोर्ट में एक काउंटर है हुजूर, प्राइवेट काउंटर, उसी से भेजे हैं आज।
सीरियल नंबर कौन ईमेल आईडी में भेजे हैं?
ऑनरेबल कोर्ट से नंबर 10 मिलर्ड्स जो।
No, there is nothing. Nothing has been received.
हम फिर वेरिफिकेशन किए, बोले कि हाँ मुंशी जी बोले भेज दिए हैं।
No, there is nothing has been written. What is the email ID you have sent?
वो तो हमको स्लिप लाके दिया नहीं हुजूर, आज ही भेजे।
काउंटर से भेजे हैं?
हाँ हाँ, वो हाईकोर्ट के प्रीमिसेस के बाहर बहुत सारी दुकानें नहीं है हुजूर, उसी से होता है। इसको हम पढ़ देते हैं हुजूर, कहा जाएगा तो फिर हम फाइल कर देंगे।
रिफ्रेश करके देखिए, स्पैम में देखिए,
या हम रेफरेंस दे दे रहे हैं, तुरंत निकल जाएगा उसमें।
रेफरेंस है कुछ?
हाँ हुजूर,
बताइए।
सिविल अपील नंबर 673
सिविल अपील 673
of 2016
2016
arising out of SLPC number,
yes,
LPC number 7233 of 2007. VC BN Mandal University and others, VC BN Mandal University and others versus the state of Bihar. इसका डेट है हुजूर 29 जनवरी 2016।
yes, find out this judgment. Supreme Court Civil Appeal 673 of 2016. (99) 1 2016 date of disposal. This for the state and the state of Bihar.
But I appeal of the state of Jharkhand, and state of Bihar is not a party. Here the university is party. Respond number 4.
This for the respond number 4.
My lord, earlier my office was appearing for university, my lord. Now, although we have no instruction, my lord, but the same was the line, my lord. So far as I recall, my lord, I have seen in my computer, my lord, same line we have taken that the matter was pending at that time. That was our counter affidavit.
Now, what is the status now?
My lord, now, my lord, Supreme Court has decided the issue, my lord.
Yes.
That is the judgment, my lord. On the last occasion, I argued. Therefore, petitioner was directed to bring it on record, my lord.
What is the judgment? This judgment.
This one.
What is this referring to?
My lord.
What has been made in that judgment?
My lord, further direction was issued, my lord, to Honorable Lokayuk to carry out. But my lord, nothing was told about these petitioners, my lord. So because I am not having filed, so I am unable to.
No, the petitioner himself says that he was not a party to the LPA.
Yes.
It is not available online. I'm asking from there. He is not going to library.
May I read the judgment, Milords?
Yes, read the judgment.
Milords, in page 9, Milords, the Honorable Supreme Court held, we accordingly request the Lokayukta in the state of Bihar to hold an inquiry into the following 3 aspects. 3 aspects को Honorable Supreme Court ने हुजूर mention कर दिया है 1, 2 and 3 regarding the institute, Milords. And thereafter, my lords, the relevant portion I am placing before your lordship, page 10. Upon completion of the inquiry, the Lokayukta shall answer the three questions formulated by us and submit his report to the Vice Chancellor of the Appellant University. Depending upon the findings recorded by the Lokayukta, the appellate university shall pass appropriate orders if necessary, in modification of notification dated 19/5/2000. And thereafter, Honorable Supreme Court observed, my lords, we make it clear that anyone aggrieved of any action taken pursuant to the report of the Lokayukta shall be free to seek appropriate redress in appropriate proceeding before the appropriate court. We also make it clear that there is no challenge to the cancellation of the degrees by anyone except the respondents herein, and the interveners and no other candidates shall either be necessary party to the proceeding before the Lokayukta or be entitled to question of any finding on the basis of the report submitted by him. My lords, thereafter,
So your fate has been sealed by the Honorable Supreme Court by that.
my lords, my humble submission that the Honorable Supreme Court's observation is.
But Mr. Counsel for the State, this writ application is pending as on the date the Honorable Supreme Court passed that order. The Honorable Supreme Court was not aware that this another writ application was is pending in another state arising out of the same cause of action. So what will be the effect of this writ application? He will be governed by the Lokayukt's order. Has Lokayut taken not?
Lord, I pray, Lord, that the state of Bihar may kindly be made a party in this, directed to be made a party in this case. Lord, they shall file an affidavit. Whether what was the report of the Lokayut?
This is party. Deputy Commissioner is party.
State of Bihar is a party.
Deputy Commissioner is the party.
Deputy Commissioner of which
district? State of Bihar है, स्टेट ऑफ झारखंड है पार्टी, बिहार नहीं. हमने सिर्फ यूनिवर्सिटी को पार्टी बनाया है.
Yes, for Bhupendra Narayan Mandal University.
I have submitted it earlier. I was appearing, my lord, with my
Who is appearing? Who is for the state of Bihar?
State of Bihar, no one is not a party, my lord.
Just Bihar has implemented as a party in this matter, but I am for state of Bihar. If any direction is given to us, lots of, then we will just filing an affidavit.
Okay, counsel for the petitioner is directed to implement the state of Bihar through
State of Bihar through Department of Education, my lord.
Secretary Department of Education as respondent number 5. Full stop. Necessary corrections should be made in the cause title by reading within 3 weeks. Full stop.
Office may kindly be directed.
No. Send someone within 3 weeks.
This is one of the goals.
Next para. Mr. Punendra Sharan appears. Advocate Leonard Punendra Sharan appears on behalf of the state of Bihar and is present in the court proceeding today. Full stop. He will seek instruction from the state of Bihar about the latest development in which has taken place pursuant to in compliance to the order and direction passed by the Honorable Supreme Court in Civil Appeal number 673 of 2016, which was disposed of on 29/1/2016. Full stop. List this case after 8 weeks.
Obliged.
One thing, a copy of the petition may be kindly served upon us.
State of Bihar.
Yes,
I will
serve a copy. The counsel for the petitioner will serve a copy upon the state of Bihar.
Milords.
Yes, upon the lawyer appearing on behalf of the state of Bihar. Okay, we meet at 2:15 again.